I would therefore maintain the conviction and dismiss the appeal. The learned government advocate made a strong plea for alteration of the conviction to one under section 302 of the Penal Code. The government has not filed an appeal from the acquittal under section 302, although such an appeal would be within time, and in the circumstances I would not think of altering the conviction, though I agree this court has the power in a proper case to do so. The government advocate then filed an appeal on 21.12.1949 against the order of the Sessions Judge Dhar, acquitting the respondents of the offences under sections 394, 392 and 302 as stated above. An objection was raised by Mr. Sanghi, learned counsel for the respondents, that in view of the decision of the division bench dismissing the appeal of the respondents against their conviction, the government appeal against the order of acquittal is not competent. Whether it is competent or not is a question referred to this full bench. Much argument has first been readdressed to us on the question whether the division bench which heard the appeal against the conviction of the respondents was or was not empowered to alter the conviction of the respondents to one under section 302 Indian Penal Code. If the bench was so empowered, it was being argued, and the bench did not consider it proper to alter the conviction from one under section 304 to one under section 302. The appeal against acquittal filed after the decision of the division bench should not be entertained. In other words, the first question for consideration is whether this court, sitting as an appellate court, is empowered to convert the finding of an acquittal into one of conviction. A mass of case law has clustered round the question, and at present it has given rise to considerable divergence of judicial opinion on the point. After the decision of their lordships of the Privy Council in Kishan Singh versus Emperor 50 ALL 722, another view emerged stating that the Privy Council had approved the statement of law that the only way in which a finding of acquittal can be altered or reversed is by a government appeal. Sharda Prasad versus Emperor AIR 1937 all 240 and Jadu Rahim versus Emperor AIR 1938 Sindh 202. On the other hand, it was held in other cases that 50 all 722 did not interpret the powers of the appellate court or the combined revisional and appellate powers of a high court, and it is limited to the revisional powers of the high court, and it leaves the authority of old cases referred to above substantially unshaken. As the question is of interpretation of section 423, which defines the powers of the appellate court in disposing of appeals, it may be convenient to quote the section itself, which states that the appellate court may, in an appeal from an order of acquittal, reverse such order and direct that further inquiry be made or that the accused be retired or committed for trial as the case may be, or find him guilty and pass sentence on him according to law. In an appeal from a conviction, reverse the finding and sentence and acquit or discharge the accused or order him to be retried by a court of competent jurisdiction subordinate to such appellate court or committed for trial, or alter the finding, maintaining the sentence, or with or without altering the finding, reduce the sentence, or with or without such reduction and with or without altering the finding, alter the nature of the sentence but subject to the provisions of section 106 subsection in bracket 3 not so as to enhance the same. The word alter has been used above always in juxtaposition with reverse to indicate that reversal of a finding is different from alteration of a finding, which is definitely a weaker term. It is obvious that there is not only the distinction between the words alter and reverse, but the distinction between order, finding and sentence is also emphasized in section 423 in bracket 1. A finding includes both a finding of law as well as a finding of fact. A finding therefore means and includes the conclusions of the court on facts which constitute the offense, the conclusion of the court that the accused is guilty and not innocent, and then the conclusion that the offense falls within a particular section of the statute. If an appellate court in an appeal from a conviction reverses the finding and sentence, the accused will be acquitted or be ordered a trial or will be committed for trial. If an appellate court alters the nature of sentence under section 423 in bracket 1 in bracket B in bracket 3, it cannot enhance the sentence, so it must alter the nature of sentence either by reducing or maintaining it. If, however, the finding is altered under section 423 in bracket 1 in bracket B in bracket 2, the sentence must be maintained. It cannot be enhanced. Where an order of acquittal is to be converted into an order of conviction, it amounts to a reversal of the order, full stop, over.